Hi there. Good morning, good afternoon, good evening, whatever time it is. As always, happy whatever day it is, and welcome. I'm Larry Erickson. This is the Erickson Report. And this episode of the Erickson Report is devoted to one topic. We are in this nation in the midst of what could best be described as a slow motion coup. A slow motion coup that threatens our future as an open society and a free people. Now, this has been developing for years. It's been coming on for years, but right now it's coming to a crescendo. It's coming to what could well be a break point where the future will be charted one way or the other. I, in the past, have talked about some of the threats involved in this slow motion coup, attacks on voting rights, on LGBTQ rights, on the right to protest, on our right to privacy. This time, I'm going to be addressing one aspect of this slow motion coup, specifically how it has been reflected and revealed in recent decisions by the U.S. Supreme Court. Now, I'll say at the top, by the way, that one of the decisions I will not be talking about, at least this time, is the Dobbs decision. That's the one that overthrew Roe v. Wade, precisely because it is the one that has gotten the most attention and the most comment. So, commentary on other things I think is more important for right now. But anyway, what I'm going to be looking at is three cases, three recent decisions by the Supreme Court. They're not as noticed or as commented on as Roe, but they are all worthy of attention because each in their own way is actually not only an attack, it is laying the groundwork for additional attacks. So I tell you what, let's get to it. The first case is West Virginia v. EPA. And it's a case that shows how far beyond the bounds of logic and consistency the reactionaries will push in order to advance their objectives. This case involved the Clean Power Plan, a proposal from the Obama administration that set strict carbon emission limits for each state in an effort to reduce greenhouse gas emissions to fight climate change, greenhouse gas emissions in this case from power plants. It combined a cap and trade system plus encouragement to those plants and to the states to meet the limits for emissions by turning over to renewable forms, less polluting forms like wind and solar. Now, the plan was challenged in court by coal states. It never went into effect. And then it was thrown out and overturned by the Twitty Pie administration, which set up its own very, very lenient set of rules, which in turn themselves got struck down in court because apparently in doing it, they had violated the Clean Air Act. What that means is that there are actually no regulations about this in place. Now, the Biden administration has said it is not going to look to renew the Clean Power Plan. It's going to start from scratch. It's going to make its own new regulations. Now, normally, this is something that would make a court, particularly the Supreme Court, say the matter's moot. There's no regulation for us to examine. There's no dispute to be resolved. But the Supreme Court said, no matter, we don't care. We're going to rule on the CPP, the Clean Power Plan, anyway. In other words, they took the case in order to do what they did. And what by the vote of 6-3, big shock, what they did was to limit the power of the EPA to regulate greenhouse gases. They said that even though the law clearly gives the agency the authority to regulate those kind of gases, it didn't give it the authority to do it in just the way the Clean Power Plan did. And therefore, the EPA couldn't do this. It used what's called the major questions doctrine, which is something recently invented by the right wing. But they use this doctrine to say that a shift from point source emission controls to an industry-wide or statewide standard is a major policy question. And because that wasn't in the legislation, it's beyond the EPA's authority, which actually is very bad news for the future regulation of greenhouse gas emissions and thus for fighting climate change. Now, there is some underlying good news here. and that the immediate impact on the environment as a result of this is going to be very limited because much of what the Clean Power Plan looked to achieve is being reached by the harsh reality of economic forces. Coal is a dying industry and is going to continue to die. It's going to continue to fade away, even as some areas that are desperately clinging to the past and apparently don't give a damn about the future are trying as hard as they can to resist that. But ask any good capitalist and they will tell you that economic reality is not going to be denied. The other partly good news here is that this decision did not go as far as a lot of people feared it would. The decision could have been much more sweeping. But that good news may only be temporary. To understand why, you need to know a little more about this major questions doctrine. See, this is how regulation normally works, okay? Congress passes a law that defines the broad goal of the legislation. A regulatory agency spends the time to develop suggestions on how to achieve that goal, which then go to a panel of experts to decide on which standards need to be set in order to achieve that goal. These proposed regulations go for public comment and review, and when finalized, they are published in the Federal Register, and then the agency in question becomes the agency to enforce the new regulations. Now, back in 1984, the Supreme Court, in a case called Chevron v. Natural Resources Defense Council, said, the court in that case said it only made sense for Congress to do it this way, that it only made sense that Congress would set the goals and the regulatory agencies, which are staffed with the scientists and experts, they'll do the science to set the rules to figure out how to achieve that goal. It's called the Chevron deference. The idea is that courts should defer to the regulatory agencies because they're the ones with the expertise in the area in question. Now, the major questions doctrine says instead that the detailed and time-consuming analysis of a problem, the developing of specific solutions, the developing of the writing of specific rules to deal with it should all be done by Congress itself. The result of this, of course, is that any proposed regulation would take years to get through. It would probably have to be reintroduced in multiple Congresses. The legislation involved would run to thousands of pages and would simply really turn it into an even bigger playground for corporate lobbyists than legislation is now. But the thing is, in order to do that just that way, you have to overturn Chevron v. NRDC. And what the thing is with the court now clearly looking favorably on this major policy, a major questions doctrine, we're already seeing right-wing secretaries of state and various corporations kind of lining up to bring suits based on this doctrine, arguing for any regulation they don't like, that if it's not in the law, the agency can't do this. In fact, that regulatory agencies are not there to research or develop any kind of standards. They're only there to be the cops on the beat to enforce the standards that Congress specifically sets. If this was done, if this would happen, if this was overturned, and one of the things they're hoping in the course of these suits, they're all hoping that at some point this Supreme Court will simply overturn Chevron, just throw it out entirely. The result would be to cripple virtually every federal regulatory agency. Every rule made by any of them, or at least any rule in the last 40 years or so, could be thrown out under a direct court challenge because unless Congress specifically authorized it to say you can't do it, which also means that unless Congress specifically took all of those regulations and introduced them as a separate piece of legislation and got it passed, fat chance of that happening now, those rules would simply cease to exist. And chaos hardly begins to define what would be the result of that. And these people apparently, they just don't care. Next up, it has to do with, well, there were 3 decisions in the past 8 weeks in which the Supreme Court has ruled against government officials who were trying to avoid violating the First Amendment's prohibition on government endorsement of religion, the so-called Establishment Clause. First of these cases was that on May 2nd, it ruled in favor of a Christian group that sought to fly a flag emblazoned with a cross at Boston City Hall. This is under a program that was aimed at promoting diversity and tolerance among the city's different communities. On June 21st, the court endorsed taxpayer money being used for students to attend religious schools under a main tuition assistance program for schools in rural areas that don't have a public high school nearby. But the worst of these, on June 22nd, the Supreme Court took a wrecking ball to the separation of church and state and overturned decades of precedent which prohibited educators from leading students in religious displays. The case here was Kennedy v. Bremerton School District, which concerned a coach who led prayers on the 50-yard line of the Bremerton High School's football field. What happened is after games, the coach, Joseph Kennedy was his name, would walk out to the 50-yard line where he would kneel and pray in full view of students and spectators, still on the clock, still in his coaching clothing. Now, eventually, a majority of his players joined him, at least some of them, according to their parents, because they feared consequences such as loss of playing time if they did not take part. In 2015, the Bremerton School Board asked Kennedy to stop involving students in his prayers because it presented the image of a school not only endorsing religion, but his particular religion. Now, in response, Kennedy did end some of his most extravagant behaviors, such as prayer groups with students around him while he held a helmet over his head during the prayers. But he also went on a media tour to outlets ranging from local newspapers to Good Morning America, declaring himself a coach who made a commitment to God. Now guaranteed large-scale media attention and conservative backing of a challenge, he went back to his ostentatious praying, and now surrounded not just by students eager to keep on his good side, but also by media. The school suspended him with pay. He sued, thus this case. So just 2 decades after the court reaffirmed that prayer in schools violated the separation of church and state, the Shrieking Six declared that preventing Kennedy from using his position as a member of school staff to proselytize to his team was a violation of his religious freedom, but not, interestingly, the religious freedom of those who felt pressured to participate and rather wouldn't. But what's even more significant here, more important here, is that the majority here simply and flatly outright lied about the facts of the case. Last year, Judge Millen Smith of the Ninth Circuit Court found that Kennedy's lawyers had created a deceitful narrative, quote unquote, about the case, finding that Kennedy, quoting the judge, prayed out loud in the middle of the football field, surrounded by players, members of the opposing team, parents, a local politician, and members of the news media with television cameras recorded the event, all of whom had been advised of Kennedy's intended actions through the local news and social media. All of that in contrast to the personal, quiet prayer his lawyers claimed that he was engaged in, a claim that the SCOTUS majority swallowed whole without even needing anything to wash it down. In fact, writing for the majority, Neil, son of Ann Gorsuch, began his opinion with, quoting, "Joseph Kennedy lost his job as a high school football coach because he knelt at midfield after games to offer a quiet prayer of thanks." Indeed, Gorse used the word quiet 14 times, embracing a vision of the facts that is demonstrably false. In the course of this, the precedent is so precious to us, gang, explicitly overruled yet another precedent. This one, Lemon v. Kurtzman. This is a 1971 decision that had governed cases involving the Constitution's prohibition on an establishment of religion for over 50 years. And now that it's overturned, how long do you think it will be before the next Kennedy brings a case to court about having organized school prayer? And do you really think this band of raging hypocrites would even pause at approving such an idea? In fact, given the opportunity, they may look to go even beyond that. The most ominous and perhaps telling observation on this case comes from Cornell Law School professor Michael Dorff, who said the court's majority appears skeptical of government decision-making based on secularism. Quoting him, they regard secularism, which for centuries has been the liberal world's understanding of what it means to be neutral, is itself a form of discrimination against religion. In the ruling, Justice Gorse wrote that the court's aim was to prevent public officials from being hostile to religion, even when that hostility consisted in effect of nothing more than do it on your own dime. Personally, I'd actually be a little more direct than Professor Dorff. They're not skeptical of government decision-making premised on secularism. They're skeptical of secular government. We are in the prospect of dark times indeed. All right, third up. The Supreme Court has found a century-old New York state law that required people to have an actual reason for carrying a concealed weapon in public. They found that this law violates the dignity of the highest and most holy part of the Constitution, and therefore the court did stretch out its arm and smite the heretic. This New York law said that to get a permit to carry a concealed weapon in public, you had to show some kind of need. You had to show a reason why you needed one. Maybe you were a stalker. Maybe you were a victim of abuse. Maybe you had to carry as part of your job large amounts of money or valuables or some such thing. You needed a reason. Now there are no restrictions. You don't need a reason. Now, the immediate impact beyond striking down the New York law is that 5 other states, California, Hawaii, Maryland, Massachusetts, and New Jersey, have similar laws that are also likely to be struck down. The bigger impact, though, is that the ruling marks what Mark Joseph Stern, a senior writer at Slate covering the U.S. court system, called a revolution in Second Amendment law, in that it declared for the first time that there was a constitutional right to carry a handgun in public. Remember the Heller decision? That just said you had a constitutional right to have a gun in your home. This one says you have a right to carry it in public. And suggests that any similar such restriction is presumptively unconstitutional. Now you'd think that the reality of a nation averaging more than one mass killing a day would give the court some pause, but you'd be wrong. Writing for the of course 6-3 majority, Justice Clarabelle Thomas said the Second Amendment is different from the other rights in the court and the Constitution, is that the courts cannot look at the real-world impact of gun violence when assessing the legality of gun restrictions. Judges are, as Stern put it, prohibited from considering any kind of empirical evidence about how gun restrictions or gun laws have an effect on the real world, including whether gun laws protect our communities or individuals from gun violence. That's supposedly irrelevant to the Constitution. All right, my question is why? Why is that irrelevant to the Constitution? I mean, every right in the Constitution, every right in the Bill of Rights involves a balancing act. You have to balance the constitutional right and the freedom of the individual versus the needs of society. It's true. I mean, consider the First Amendment. Okay, consider the classic case in the First Amendment of saying that you can't falsely shout fire in a crowded theater and then say, well, that's just free speech. I'm not responsible for anything that happens. Well, no, you're not. It's beyond the bounds of free speech because it creates what's called a clear and present danger of a panic that could lead to people being trampled, injured, even killed, plus the property damage. But note that the restriction is not based on the words themselves. It's based on the effect of the words. So in the face of a clear statistical and robust relationship between the rate of gun ownership in an area and the rate of gun crime in that area, the clear relationship between the number of guns in an area and the amount of gun violence in an area, it seems irrational to me to argue that the Constitution must be silent on gun violence even as it speaks on the violence of shouting fire in a crowded theater. Now, it's true, you cannot guarantee that this decision, this Supreme Court decision, will not lead to more violence. You can't guarantee that. But neither can you guarantee that the shouting of fire would lead to a panic. But in both cases, they are clearly foreseeable results of it. Meanwhile, in the face of the evidence that gun restrictions of various sorts have existed across our history, and that in the 18th and 19th century, American states regulated guns a lot more than we imagined they did. Clarabelle dismisses all this as historical anomalies while cherry-picking his way through the record to claim that, in effect, that the only gun laws that are legitimate are those that are in line with what would have been accepted in 1791 or when the Second Amendment was ratified. So the only way a state could save its gun restriction is if it can either, it can show that it's a restriction that was accepted and a practice would have been common either in 1791 or maybe in 1868 when the 14th Amendment was adopted. This is a sloppy, a dilettante approach to history. Clarabelle here works without context, without any broad understanding, simply plucking out preferred examples and ignoring the rest. This, by the way, is a continuing problem with the history that these injustices offer. And the thing is, doing this is fine for a partisan advocate. Partisan advocates do it all the time. You try to make your strongest case. The left does it, the right does it, I do it. You try to take the evidence and present the most persuasive case for your view that you can. Prosecutors do that in a trial. Defense attorneys do it in a trial. Try to point to the parts of the evidence that most strongly support the narrative they're trying to establish. For that, that's fine. But he's not supposed to be a partisan advocate. He's supposed to be making an impartial, educated overview of the background analysis for a decision by the United States Supreme Court. Which is the point. This should not be seen as a Supreme Court decision, but as a right-wing gun nut screed. But unfortunately, one having very real-world consequences, including giving the NRA and the other bloodthirsty gun nut fronts for the gun industry a basis to challenge dozens and dozens and dozens of gun laws well beyond New York, well beyond the issue of handguns, saying that all of the courts that upheld all of those were all wrong. In fact, according to Michael Waldman of NYU's Brennan Center for Justice, Clarabelle's manifesto, quote, calls into question a wide variety of gun laws, including key provisions of the Senate gun bill, the one that was just passed, because, for example, high-capacity magazines didn't exist in their old days, just as there were no laws dealing with domestic violence or even red flag laws. Clarabelle Thomas and the rest of the seditious six are going to get people killed. But don't worry. The Senate has unanimously passed a bill to expand security protection to include members of the immediate family of Supreme Court justices, so, it's all good. Now, as a footnote to this, to show just how vapid this whole thing is, in its concurrence on the case, Sham Alito sneered, how does the dissent account for the fact that one of the mass shootings near the top of its list took place in Buffalo? The New York law at issue in this case obviously did not stop the perpetrator. That's the kind of argument that might be produced by a mediocre fourth grader. I mean, he clearly does not believe that laws against abortion are pointless, even though everyone knows unlawful abortions will continue just as they continued before Roe. Frankly, I'd like to ask Shammy to cite just three laws, that meet his standard of being valid only if they completely eliminated the crime that they sought to contain. Come on, Shammy, put up or shut up. Okay, finally for this time. This is a case that has not been argued, not been decided, but that is accepted for argument at all, and it may actually be the most dangerous one of all. The Supreme Court has announced that it will take up the case of Moore v. Harper in October. The supposed central issue is a gerrymandered district in North Carolina, gerrymandering that conflicts with the state constitution. But the real issue is the so-called independent state legislature doctrine, an insanely dangerous doctrine that would make voting for president a pointless enterprise. Here's the deal. Article 2, Section 1 of the Constitution lays out the process for choosing the president. I'm going to quote it, but this is a very edited quote, just to save time. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled. The electors shall meet in their respective states and vote by ballot, which list they shall sign and certify and transmit sealed to the President of the Senate, who shall, in the presence of the Senate and House, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the President. That's what's laid out. It's pretty straightforward, okay? But note what's not mentioned in there. Voting by anybody except the Electoral College, the chosen electors. The independent state legislature doctrine, which is first invoked by 3 members of the Supreme Court in Bush v. Gore, the 2000 case that installed George Shrub into the presidency. This doctrine's claimed doctrine relies on the first part of that quote. Every state shall appoint in a manner as the legislature thereof may direct a number of electors. They use that quote to hold that state legislatures have the final and absolute say over presidential electors for their state. The will of the voters be damned. Your vote actually doesn't count. Indeed, the doctrine even claims that this power of a legislature, because it's set in the federal constitution, overrides any contrary provision of any state constitution. Now, one of the reasons that the January 6 coup failed is that every contested state had laws on the books requiring all of their electoral college votes to go to whichever candidate won the popular vote in that state. And being a law passed by the legislature, it becomes the manner in which that legislature is so directed and so meets the standard. But that remains true only so long as those laws are unchanged. And goppers are already gaming out which legislatures need to change their laws in order to remove that annoying impediment to their lust for power. And this Supreme Court may well be prepared to actively aid them in that endeavor. Watch this space. And thanks to Tom Hartman for the heads up. All right, so that's it for now. There's other things. I'll probably be going back to this next week. But for the moment, I'm going to leave it there, except to say this. And again, I'm sure that I'm going to come back to this next week. We cannot depend on the Democrats to do this. We cannot depend on them to save us from this. Voting harder is not going to be good enough. We cannot rely on them. And I'll go into more why next time. But just consider this for yourself very quickly. Do you think that voting rights were won in the halls of Congress? Do you think women's rights were won there? Do you think the Indochina War was brought to an end there? Do you think environmentalism was established there? Do you think any of that stuff and more were established in the halls of Congress? They weren't. They were established in the streets. Congress responded to the public pressure and public disruption in the streets to deal with issues. And that's what we have to keep in mind. Voting harder is not going to save us. We'll see you in 2 weeks. I'll be talking more about this. In the meantime, you have the best 2 weeks you possibly can. As always, peace.